The South African Bar Association is a voluntary association of LPC registered advocates operating nationally with its head office based in Inovo Center. With its membership drawn from all 9 provinces of South Africa, the association has seen rapid growth and is destined to become the biggest bar association in Southern Africa in years to come. The South African Bar Association is a LPC accredited vocation training provider and conducts pupillage training for aspiring advocates. The ongoing training and development of junior advocates and legal practitioners is a cornerstone value of the association, who thereby seeks to improve the quality of legal representation in our courts. The association's flagship afternoon programs have won the respect and support of the judiciary, academics, and practitioners alike. But most importantly, the association is committed to advancing the cause of female legal practitioners and is continuously exploring and supporting initiatives aimed at making this objective a reality. Membership of the association is free for practitioners starting off in the profession. It is only after the 3rd year of practice that a nominal membership fee is required. For more information, visit the South African Bar Association at www.rsabar.net. The South African Bar Association, transforming the legal profession.
Good afternoon, ladies and gentlemen, and welcome to the SA Bar Association's afternoon program. You're well aware, illustrated by your attendance, that we've moved our weekly Thursday meeting to today purely because of the Easter holidays. The South African Bar Association hosts a speaker every week to deal with a legal or advocacy-related topic. These sessions are attended by advocates, attorneys, students, and interested parties, and are presented at no charge to our participants. The objective behind these sessions is to capacitate legal practitioners, and by so doing, to improve the quality of legal representation in our courts. Today, our guest speaker needs no introduction. Judge Sutherland is a well-respected role player in our legal fraternity, and it's not difficult to read about him on the internet, social media, and other platforms. Judge Sutherland, thank you so much for taking the time to participate in the SA Bar Association's weekly training and information program. You're going to share with us today the mode of hearings in the Johannesburg High Court in the 2nd and 3rd terms of 2022, and then matters incidental thereto. Just before I hand over to you, Judge, might I remind our delegates of the protocol during our afternoon program? You're welcome when we get to the Q&A session, of which I'll tell you a little bit more in a moment. You're welcome to post your questions in the chat box. I will facilitate those questions and convey them to the platform. You can also raise your hand, and I'll ensure that chronologically our delegates have an opportunity to participate with questions to our guest speaker, the Deputy Judge President Sutherland from our Johannesburg Division of the High Court. Could I also remind our delegates to turn off the cameras and ensure that the microphones are muted. Without much further ado, Judge Sutherland, over to you. The Q&A question starts more or less depending on how our program develops from 22 and 4:45. It's a hot topic. We're all very curious to hear what you're going to share with us, Judge. And thank you very much again. Over to you.
Well, thanks very much for that, and good afternoon to everybody. Thank you for taking the trouble to get yourself up to date and briefed on developments that are going to take place during the second and third terms. The first issue, I suppose, that I should alert everyone to is that I don't really have a great deal to say. What I need to say can be done quite briefly. And I'm sure that most of what we should spend our time on this afternoon is hearing your queries on specific issues that probably need a bit of finessing. And so with that in mind, I want to address then what will be happening in Gauteng generally, and more specifically in Johannesburg, concerning video link hearings, the utilization of case lines and court online, which is probably still unfamiliar for most of us. And thirdly, I want to make some remarks about, in Johannesburg particularly, innovations we want to introduce, having regard to our limited judicial capacity, to cut down on the lead times on various matters that are on the roster. So with that in mind, let's get to grips with where we are and where we need to move to. We know that the COVID state of disaster has now been terminated, and effectively from the 15th of April to the 15th of May, we are in what I suppose we would call a transition period, although it's difficult to see what's different. At the very outset of this pandemic, it was a decision taken by Judge President Malamba that the High Courts would contemplate a return to physical hearings when the state of disaster was cancelled. So that, for our practical purposes, it doesn't really matter what date officially it is. The state of disaster ends in the course of the second term. The second term's organization of work has been determined on the basis that there will be remote working to some extent. And in anticipation of the state of emergency being totally over and us being able to return to full physical life, from the 17th of July, which is the first day of the third term, we expect to be back fully physical, except for some reserved matters, which I'm going to deal with in due course, which we think, after having consulted with the leadership of the professions and with the bench, ought to remain by remote link permanently. So let's see where we are now. We're still governed by the Judge President's directive, which was updated and revised as of the 11th of June 2021. And in it, paragraphs 4 and to a lesser extent, other paragraphs tell us what the default position is going to be regarding the hearing of matters. So where we are now, the rule is simply this. The default method of hearing is on a video link. Where good cause exists to ask a judge to exercise a discretion to have a physical hearing, because either of forensic practicalities or because health concerns can be properly catered for, such a request could be made and the judge at his or her discretion would decide to have a physical hearing. That's where we are now. At a meeting of the Johannesburg judges in the last week of last term, certain decisions were taken about how we want to transition back to full physical hearings in August of next year, or 17th of July, if you want to be pedantic, the third term. Interestingly, other than the descending health risk, one of the issues that arose that might inhibit practitioners in particular from wanting to come back to court was the condition of the High Court precinct. I'm happy to report that the city is at last taking a serious interest in the High Court precinct. And having spent the last term physically in chambers, I'm able to attest to the changes which have taken place for the good. The mayor has come to visit us, and we've had 2 members of the mayoral committee concerned with various aspects of inner city development come and see us. And the consequences of that is that the High Court precinct has been thoroughly cleaned and thoroughly policed. There are JMPD officials in evidence almost everywhere, and the incidents of squalor and of delinquency would have diminished considerably. So from that point of view, there really is very little excuse for practitioners not to want to come back to physical hearings in the High Court in Johannesburg. There is, of course, the commute. None of us have been missing the commute from home to court, but that is part of life that we will all have to get used to again. I regret to inform you that the traffic is at present as bad as it ever was, which suggests that a great number of people are physically back at work, and the critical mass is there. So practitioners will have to accustom themselves to finding a decent cup of coffee nearby and coming into court in greater measure. So what's going to change? In the course of the second term, the rule now is slightly different, but with some important finessing, which I'll emphasize in a moment. Our rule in Johannesburg is going to be that the default method of hearings for the second term is video link, subject to the discretion of the judge to order a physical hearing. That discretion will be exercised in 2 ways. First, the parties will request it, in which case there will then be a physical hearing. And secondly, the judge may take the view to initiate a decision to hold the hearing physically, in which case the parties will get not less than 48 hours notice, that it will be a physical rather than a remote video link hearing. That applies to everything except for the following. Number 1, the urgent court. All after hours urgent matters, that's after 4 o'clock and in the weekends, will be done on video link, and it will remain on video link permanently. We intend that to be a permanent feature of the way the work is done. So there'll be no more scurrying off to court at 10 o'clock or on a weekend, unless, of course, there's some special reason for it, but that will be the default, and it's anticipated that will remain the default permanently. Secondly, the unopposed divorce court will remain a remote link until we think it's wise to do otherwise. There are a number of reasons for this. The principal one is to avoid a random number of litigants who are usually accompanied by at least one friend coming into court, a different set of some 80 people every week. We think that is a prudent step to avoid the risk, however diminishing, of bringing COVID into the building. I dare say it will also help in limiting the amount of influenza that is brought into the building too. So what we propose doing is continuing to do unopposed divorces in that manner. They will be done on affidavit as far as possible, and practitioners are encouraged to spare your plaintiffs having to give oral evidence, depose to the affidavits, and generally speaking, those areas that will require further elaboration and a witness in the form of the plaintiff to be present to give evidence on a remote link are going to be involving children. And so what is in the directive will remain in force permanently, and we'll revise and reconsider that at some later time, but certainly not before the beginning of 2023. Then applications for leave to appeal will continue to be done remotely. The reason for that is that frequently, in order to have them heard within good time, a judge has to squeeze that into either the space before court begins or after court, occasionally sometimes at lunchtime. When everybody used to be in town and practicing law didn't require you to do more than walk across the road, frequently applications for leave to appeal were held at lunchtime, no longer practical for self-evident reasons. So all of those will be arranged typically at 9 o'clock or at 4:15. And this will obviate counsel obviously having to come through the peak traffic for no other reason than for an hour and a half's engagement, and will also enable judges to dispatch that sort of work much quicker. We anticipate that remaining a permanent feature. Then there are the case management meetings in our case management conference court. We anticipate that those would be physical, would be subject to the same rule. At the moment, default remote, but increasingly physical. But all the ad hoc case management matters, where typically in a family matter or in a commercial court matter or in some other matter of complexity, where frequently there are 4 or 5 or 6 sets of counsel, we will, subject to the judge's discretion, continue to have those remotely, which will save a great deal of time on the part of practitioners in commuting into town at awkward moments, and we can get a lot more work done that. So to sum up, you can expect that the urgent court after hours, the unopposed divorce court, applications for leave to appeal, and the ad hoc case management meetings will all continue to be video link even in the 3rd term, and it will continue to be so until such time as we change our policy choice. So that you can look forward to doing for the whole of 2022. There is one other matter about which there's currently a discussion going on, and that concerns admissions to practice. It's been a sad thing in the last 2 years that practitioners have had to be admitted remotely. It spoils what is an important day in one's career. And our sense of it is that we will probably go to a position where all admissions ought to be done in physical court. It's an occasion where one often brings one's spouse or one's parents along, and it ought to be a special occasion and not something simply done over a computer. But there'll be more notice about that in due course. I say that because that's one of the issues that is in a draft guidelines for how to deal with matters after the state of emergency, which Acting Judge President Ledwaba has circulated to the professions today. It's probably unlikely that many of you would have had a chance to see it. You'll probably see it pop up on your screens this evening or tomorrow. And in that, there's a series of guidelines which are out there to solicit comment from the profession. And the general thrust of it is exactly what I've told you is the Johannesburg position. There's some elaboration which is worth thinking about. In the draft, it says that in matters where evidence is required, obviously there will be a second look at whether or not that's practical to do over video link. As you know, all criminal work has been done physically for self-evident reasons. And to the extent that we can resume hearing physical hearings for civil matters, that's going to take place. There is the option in due course of exploring hybrid physical and video link hearings, particularly with experts and other witnesses who are out of town. And that's something we're going to have to lead with our noses on, because the practicalities of that have yet to be tested. One of the things that you need to bear in mind about a physical return to court is we're not going back to December 2019. Case lines is front and center, an example of the digital way in which we will be doing practice. And Court Online, which I'm going to talk about a bit more in a moment, which is going to take over part of the attorney's process filing aspects and into some of the things we've been using case lines for over the course of this year. Pilot project is on its way for the duration of the second term, and with any luck, that will become the default process for all litigation in the third term. So you need to alert your attorneys to that if they're not on top of it, and you'll obviously have to bone up on how Court Online works so that you can assist in dealing with that. But the implications of this are quite significant. If all 41 courts in Johannesburg are operating in July, August of this year, what you're going to see is the judge is going to be there with his or her laptop, 2 counsel with their laptops, 2 attorneys with their laptops, maybe a couple of clerks with their laptops, maybe a client with a laptop, not to mention the witness looking at a laptop to see documents. And in some cases, you may find that the judge will be there with 2 laptops. That certainly is the way I'm going to be working. That's a lot of laptops in one court. Multiply that by 40. Never mind the unopposed motion court, where there are 50-odd matters being heard. And let's say there's 35 counsel, each one with a laptop, some accompanied by attorneys with their laptops. The burning question is the IT system in the court up to taking care of all of those individuals accessing case lines or Court Online simultaneously? Now, the short answer, I have to be frank with you, is we don't know. I have posed this question to the people who are supposed to know, and they give me a very bright smile and say, of course, Judge, everything is perfect and nothing will go wrong. Well, we'll see. But that is something that, of course, affects the viability of a total return to physical hearings. It's one of the strategic considerations which is anterior to our desire to phase things in over the course of time and to use the second term effectively as an experimental phase in which more and more matters will be held physically, and we can test whether the system actually stands up to it. So what is going to happen there is that the judge in the second term, hearing whatever matters are on the roll, may well in certain circumstances decide that it's more fruitful to deal with certain kinds of matters physically. The unopposed motion court is perhaps one good example. The cap on matters in the second and third terms per judge per day is now 50. And there have been instances where that's taken a whole day to get through. It seems to be the experience of some judges, although not all, that a physical hearing means that they can be done much more quickly and probably get through those matters before lunchtime. The reason for that is, as you will have all found out empirically, doing work digitally and on a video link takes much more time. I've been given an American study in California, which suggests that their experience is that it takes 30% more time to dispose of work digitally on a video link than it would otherwise do in a conventional court. That seems a bit much, but it may depend on different procedural requirements. Certainly, one of the things that perhaps is not all that visible to practitioners, but is a source of great frustration to them, is how long it takes you to get your order back from the registrar. And at the present moment, in let's say a trial, once the matter's done, let's suppose you've settled, you can fax or rather email a draft through. The judge can have it signed and sent back within an hour. But if you have to have 50 or even 40 of those, the amount of back office work to be done by the judge's secretary is enormous, particularly where practitioners are not sensitive to this process. So let me conscientize you on what's got to happen at the moment. It's not an ideal system, and you can rest assured that various people in the court administration are applying their mind to how we can eliminate all of this. But if you've come to court in an unopposed motion, and the draft order which you've put in is accepted without amendment, what is required for you is in any event to email a Word version to the judge's secretary. He or she will have to download that. If you've omitted to put the judge's name in, if you have omitted to remove draft, that has to be edited out. So that will have to be downloaded and edited by the judge's secretary. Then it will have to be emailed to the judge if the judge is not in the same place as the secretary, which is the current position. The judge then gets it. Most judges don't have electronic signatures, and in any event doesn't necessarily mean that the Word version that he or she is receiving is capable of having an electronic signature attached. That has to be then downloaded, physically signed, scanned, and emailed back to the secretary, who then has to go and get it stamped in another office and then transmit by email and have it uploaded to case lines. So that is, to put it mildly, an agony. And we're working on ways to eliminate all of those administrative steps. And ideally, one of the things that we're working on is a utopian situation for the moment, where counsel will walk into the unopposed court. If your order is in perfect order, you can have it signed and stamped, and you can walk out with it and give it to your attorney the same day. That would eliminate a great deal of delay and lots of senseless bureaucratic nonsense which presently is carried on. So let's have a look at some of the implications of this transition. Different judges will have different views. I've mentioned the one concerning unopposed motion. Certainly, I know that some of my colleagues have a full intention of doing so for the very reasons I've mentioned. As far as trials are concerned, I would imagine that on balance, any trial where credibility findings need to be made ought prudently to be wanted by all parties, practitioners included, to be heard physically. Much easier to deal with those kind of matters in that form. But many matters don't have any credibility issues, and it's a paper war with witnesses addressing certain nuances which need to be done. And the fundamental, the important part of the case is really the argument. So it may well be that, to take two typical examples, appeals and opposed motions can just as conveniently be done remotely. And we may want to do them remotely. In the fullness of time, a remote hearing is going to always remain an option at the request of the parties, or in the case of the judge taking the initiative, for whatever particular reason there might be for that. One of the things that is of great advantage to the judges, although it probably doesn't matter much to anyone else, is dealing with matters during the recess. If you are rostered to do, say, the unopposed motion court in the course of the recess, and you want to go away with your family to another place, you're able to do your week from wherever you are, whether it's Puff Adder or Plettenberg Bay. And that would suit everybody, and indeed probably be very popular, because as counsel, if you also want to go to Plettenberg Bay, you can run your court from there too. So the probabilities are that we are going to engage with recesses being done as a default method by remote video link as well. And that would mean that particularly over the December-January period, where increasingly people do want to be somewhere else, we'll run all the work that the court needs to be done because people want it to be done remotely. The other courts, of course, stand in a in-between situation. One of the things that is going to change over the course of this year, my target is to have all these changes completed by the beginning of 2023, involve the RAF litigation in particular, about which I want to say something, and its ancillary support. As you know, we've got 2 interlocutory trial courts running, which are dominated by RAF matters where the RAF simply hasn't come to the party. In addition, we have a settlements court, which is dominated by RAF matters where the orders have to be interrogated for integrity, effectively. And we've got the case management court, where we have 1 judge at the moment dealing with those matters that, in fact, have had some kind of engagement. Largely, they're matters involving the personal injuries claims in regard to the MEC for health and for PRASA. Now, to put it bluntly, the volume of resources that are being devoted to these matters is disproportionate to the value that we are getting. I'm contemplating some reforms which will eliminate some of the elaborate procedures that we have instituted to deal with the RAF dilemma. The principal policy choice for the trial interlocutory court intervention on getting effectively a referral to go for a default judgment is to give practitioners effectively a rescission-free default judgment. And so far we've been successful. But as the RAF increasingly gets its act together, the volume of such matters ought to diminish. And in any event, we think it's appropriate at this stage to move to a new level where we regulate that doesn't consume as many judges as presently. You're probably not fully aware of this, but we simply don't have enough judges to do all the work comfortably. And when the burden of what is effectively ancillary court work in the ones I've mentioned takes out 4 judges, it makes a huge dent in the judges that we can marshal elsewhere. The main victim, this is the second point I wanted to make, the main victim of siphoning off so many resources for RAF has been the unopposed motion court. Unopposed motion court lead time at the moment is almost 5 months, which is unspeakably unacceptable. And you will have noticed the circular which I sent out some time ago, which indicated the changes that are going to be made there. There will be an increase in the volume in the second term and an even greater increase in the volume in the third term. I'm taking advantage of the curious quirks in the role to have a big bang motion court in the second last week, where we're going to have as many as 8 judges doing unopposed motions, and we're going to try and bring down the unopposed motions in that fashion. The number of requests we get for unopposed motions are running at roughly 300 a week. So if we're going to get the lead time down, we have to be able to do more than that. And these big bang motion courts, which I'll arrange from time to time, are designed in order to bring that down. Optimally, I want the unopposed motion court to be a maximum of 4 weeks waiting. So that will bring it into proper relations with the opposed motion court, where there's a 3-month waiting period, which is wholly satisfactory in relation to briefing counsel, getting ready, filing whatever needs to happen, and getting the judges and giving the judges an opportunity to read the papers before the day in question. The other matters concerning appeals, I want to introduce some reforms there as well, so that we can have a regular pattern of appeals throughout the term, instead of concentrating matters all in a few weeks and having some weeks with no appeals at all. And I'm hoping that will both be more comfortable for the judges and more convenient for counsel who want to take advantage of being in the appeal courts as specialist appeal advocates. So that really covers what I have to share with you. And I look forward to hearing what questions you have concerning problems that you might have, or queries you have in regard to how things are going to be going forward. I can't speak for Pretoria, but I can only suggest that the differences there will be quite marginal, and you can pretty much expect the division to operate on a uniform basis.
Thank you very much. Thank you very much, Judge. I'm going to ask our delegates to please use the raised hand facility. My co-presenters, and I refer specifically to Bart Ford and Romeo Ntabeleni. If you can access the chat box, which I'm struggling to access on my side, I'd appreciate you just raising your hands and then sharing those questions that have appeared in the chat box. Judge, from my side, and specifically with reference to our junior practitioners, the access to the Wi-Fi at court itself, in other words, and I say again, especially in relation to our junior advocates, will there be Wi-Fi access for them at court, or are they expected to use their own data?
Happily, I can report that what's been reported to me is that every single court will be Wi-Fi enabled. That's not complete at the moment, but it should be certainly by mid-year. And so that should be in order. And of course, that's absolutely critical to be able to function properly on case lines or court online. What is not clear to me is power. I imagine one's going to have to operate on battery. And for that purpose, I imagine the prudent advocate is going to have a second battery in order to be able to sustain power throughout the day. The older one's PC gets, the more tired it gets, and it gets more tired quickly. But that seems to me to be a prudent arrangement. In the fullness of time, one will have to have PowerPoints throughout the advocates' desks. That's not going to happen in a hurry for self-evident reasons. So until that can happen, battery power is critical.
I might mention that in Pretoria, I noted that on some of the physical appearances that the courts that we've been to have in the meantime been fitted with multiple electronic plug points. Judge, that takes me to my next question. The court online, is there going to be a generalized rollout for training on court online?
There is. It's taking place incrementally. At the moment, there's going to be a one-on-one training session with all of the judges and their secretaries. That's taking place as we speak. And increasingly, in liaison with the leadership of the profession, there'll be opportunities for attorneys to do so. The pilot has taken the shape of a number of attorneys' firms who volunteered to pilot the scheme. And they are training and are effectively using the system in selected matters in order to see what the tweaks and errors and problems are. And a few have been found. Some of that software is going to have to be rewritten. So once we've got beyond the pilot phase, it'll be rolled out, and obviously training is critical to the profession if we're going to have that as the default position. I can't tell you when there'll be a changeover which will effectively say, on this date, no more process will be received on case lines, you must go on court online. That may be as late as say, the beginning of the recess. If I think administratively about how it could be done without too much agony, I would think that probably the first day of the June-July recess would be the day that no more case lines could be used. It could be earlier, but I'm not sure that it's convenient to have it other than a critical cutoff date of that nature. That's something that's still under review. And when I meet with the pilot committee, we'll see to what extent the pilot is running out. And of course, as you quite rightly point out, the training.
Yes.
If a critical mass of the profession can't be trained by the end of this term, then making it compulsory to use court online is senseless. So that's the state of play on that.
Thank you, Judge. I'm going to play a little bit of Russian roulette from my side, in the sense that I cannot see raised hands and I cannot see questions. I'm going to open the floor to our delegates, Judge, if that's okay with you. Alternatively, between AJ and Bart and Romeo, if you would mind facilitating from your side in sharing further questions.
Yes. What's this? Everybody's suffering from recess fatigue.
Yeah.
There's Romeo. I can see Romeo wants to.
Ronald, I think you should continue to handle the questions. And as you have rightfully said, I don't think that we can have access to the questions and answers on the chat box. I see Advocate Akaji has raised his hand. Let me allow him the floor. Advocate Akaji, the floor is yours. Thank you.
Thank you, Romeo. I saw.
Good afternoon, DJP.
Hello.
DJP, at our last meeting, if you recall, our quarterly meeting, I think you raised the option of maybe making some of these, of making mandatory mediation part of the RAF processes in order to ease the burden on the court.
Yeah.
Now, if that works out, it will be absolutely brilliant. I mean, it would certainly free up a lot of judicial resources. However, we have had a meeting with the JAA and the JSA, and a lot of reservation has been raised as to whether, one, the Road Accident Fund, one, has the resources, and two, the will to make that system work. And the one concern raised is that it might end up being yet another stumbling block in bringing matters to expeditious resolution. So I'm not sure how well that is going, but there will be a communication that will be addressed to you in due course. Yes. in respect of that.
No, thank you. No, we certainly need to keep talking about that. I'm not confident myself that a mediation intervention in RAF matters is a silver bullet here. It's part of what's being contemplated. From the court administration's point of view, what would be wonderful if we had a rule that simply said we're not going to enroll a single RAF matter until we've got a certificate from a mediator saying that mediation failed. But I know perfectly well that what that's likely to do is to allow claims to heap up by the thousand. So unless the RAF does have that capacity, which you rightly point to, it's a meaningless obligation to impose on them if they can't come to the party. And once again, you know, mediation, whether voluntary or compulsory, can't be imposed until there is a ready body of mediators available at relatively short notice, at appropriate fee levels, and with the requisite skills to engage in these matters. It's rather like the situation you have with your children at school. There's no point in making sport compulsory if you can't give everybody a game. So you can give the first team a game, but if you've got kids for the second, third, fourth, fifth team and there's no games, there's no point in making it compulsory. So this is a bit of a chicken and egg situation. There is draft legislation of which I've made mention coming out of the Law Reform Commission, which contemplates making mediation compulsory. I haven't digested it myself yet, and there are important policy problems around compulsory mediation as opposed to voluntary mediation. And where that's going to go, it's simply too early to have a discussion yet. So that is something that we'll need to engage the professions with in the fullness of time. But my guess would be is that mediation as an effective intervention will not be something we will see at any critical level during the course of 2022.
Thank you, DJP.
Judge, the way, and there's an apology from Bart Ford saying his connection is very poor on his side. The multiple platforms, remote platforms for motion court. If I see my notes properly, can we expect the default setting for unopposed motions going forward on the long term to then remain remotely for unopposed motions? And to what extent will that apply to opposed motions?
Yes. Well, at this stage, the thinking is that both of those will be held physically. Almost certainly by the third term, all unopposed matters will be dealt with physically. Full stop. There may be some reason to allow something or other to take place remotely. I can think of only two reasons. One would be an out-of-town counsel is moving an unopposed motion, quite a rare thing, but certainly if you've got, say, a reduction of capital matter in a big corporate outfit, there might well be something of that nature. One of the situations where one might expect a silk and a junior to appear even in an unopposed matter, but those are quite rare. And the other issue, of course, is this: is if we have a wave, and never mind whether the state tells us to go and lock ourselves up or not, if it seems sensible to me or to the individual judges presiding that for some weeks it's prudent not to have physical hearings, that's exactly what's going to happen. There'll be a notice going out either generally or for the particular court saying no default hearings on this and that and such a date. We're going to go to video link. So we've always got the option of clawing back that. As far as opposed motions are concerned, the jury's out on whether it's more convenient to hear those matters online or physically. I suspect it matters a great deal about what kind of matters they are. But by the third term, our view is the default method of hearing will be physical, unless there's a good reason to go video link. The second term, by contrast, the default will remain video for the whole term. And increasingly, as people show an appetite for physical return, that will be accommodated, and the judges themselves may initiate a physical hearing. So what I'm anticipating is that particularly when this transition period, the sort of extra month tail on the state of disaster expires, people will become more accustomed to physical hearings, and we'll come back. To put it quite bluntly, if people can go to Tasha's for a cappuccino, they can come to court and have their matter moved. So there's not going to be much sympathy with people being too timid to move around because they're afraid they're going to get sick. At some stage, we're going to think that's an excuse because they'd rather sit at home and drink their own cappuccino than come to court.
Judge, in anticipation of this afternoon's program, as you can imagine, there was quite a lot of debates and discussions going on. In fact, it's been going on for a little while as matters improved from the pandemic point of view. One comment in one of the discussions that I was involved in, as far as returning back to physical court is concerned, is somebody said, if the pandemic projected us into the 21st century as far as tech is concerned, and in 2 years we've, whether we wanted to or not, have been exposed to the electronic platforms that are available to us. We are now consulting a lot more because it's geographically unlimited and we can see a lot of people in a lot shorter space of time. What would the motivation be behind then going backward to the pre-IT tech phase in our judicial environment? And especially, Judge, sorry to interrupt you, especially if one keeps track of how the hearings in the Constitutional Court that take place daily continue to take place on the live stream. We watch it all the time. Why? What's the motivation behind going back?
Well, look, I think the first point to make is that I think if you start off with the premise that we are going backward, you're probably asking the wrong question. Because we are human beings and we live in society, our natural habitat is in the company of other human beings, and so we can't become some kind of add-on to the cyborgs. We actually have to live as humans in a proper society, and it's just healthy psychologically to do so. But there's a couple of prosaic reasons why we should go back physically anyway when we can. The first is that if you think about how you develop your practice as an advocate, for many, many years, I've tried to drum into the pupils to whom I've given lectures is that the only way you can secure a mature and stable practice over time is by establishing your market credibility with attorneys. And when you arrive at the bar, you arrive as a blank sheet with no reputation. You can only develop your market credibility by being seen to do work and to do good work. And so as far as the development of the profession is concerned, more especially for the bar, being in court physically, engaging with other people, and being seen by people who've never heard of you before is part of how you actually earn a living. And we know that the junior bar has suffered as a result of COVID, more than the middle or senior bar. And it's for the very reason that I've expressed, is that once you've been in practice for 10 years, you've already established a reputation. People will know where to find you. And if their colleagues say, who can do this kind of matter, they'll mention your name. But if you go blogs you arrived during COVID, you know, who is that? So that's a professional reason why we should go back. There's another reason, and that is the court administration itself. The amount of additional work which is imposed on a workforce that has not increased in number and nor in skill set is quite considerable. And although increasingly we're going to be using IT and other tech devices for the administration, I think we have to just face this fact, is that the government's administrative apparatus is still medieval. Something that shocked me when I discovered it is that many of the things that have to be done by the court administration after they have received emailed court process requires them not merely to download those documents, but to print them and then go and deal with them physically. Now, it's wholly unsatisfactory, but that's where we are. Yes. So we've got to ease the pressure on that so that we can gradually get somewhere. At some stage, too far away to start dreaming yet,
Yes.
The entire court administration will have to be computerized. But as we know, there's no money to do it. And I don't see any political will to spend what little money we have on the administration of justice. And then of course there's one other reason, which I suppose might be esoteric, and that is the profession is not an island. It and its activities are part of the economic engine. It might sound a little precious, but people who make their living out of serving coffee to advocates who have to have tea at 11 o'clock in the city also need to eat. And all kinds of other merchants who feed off the momentum that is driven by people moving around and doing stuff. I think that's part of being a citizen. So those I think are the principal reasons why, however convenient it is, and I don't deny it's not being convenient. For those of us who have homes where you've got a study that you can isolate yourself from your family and your dog, and you can work just as merrily there as you might have done in chambers, that's fine. But many people, including some advocates and not a few article clerks, when they were working at home, were sharing the kitchen table with their spouse or their other siblings or other members of their family.
Indeed.
Not everybody's got a fancy study at home where it doesn't really matter whether they're at chambers or at home. So there's a whole range of these things, and I think we'll be a happier society once we're not afraid of walking around and engaging with one another.
Oh, absolutely. Absolutely. I think, Judge, there's Romeo again. Let's hear what Romeo says.
I think I'm able to access the chat now, and there's a message that was posted by Advocate Kaji, who said the issue of vaccine mandates also have to be addressed. And then Noklunga Makopo says that thank you so much. Our DJP has answered most of my concerns, if not all. Yeah. So I think those two are the ones that came into the chat box. You can continue, Rana.
Yeah. Well, can I answer those questions? I'm waiting on the heads of court to disclose what they've decided about a vaccine mandate. And in common with other institutions around the country, that of course is a likelihood. You know, I've already made my views clear, as opposed to judges engaging with one another socially. The letter which I sent to my colleagues was then leaked to the press and gained some notoriety. I think that it's a matter of civic responsibility to contribute to our herd immunity so that we can do the very things I've been talking about, getting back together. And obviously, the levels of danger now are diminishing. And at some stage, of course, we'll be in a position where a vaccine mandate won't be a critical requirement. But we'll have to see what the new health regulations have to say. I'm certainly not going to be going to the FMB stadium anytime soon if they don't have a vaccine mandate. And certainly when I do go around and I pop into Tasha's for my cappuccino, I'm careful about wearing a mask and whether or not there's some decent social distancing going on. And I think many people are going to do that for a very long time. Some shops are probably going to insist on social distancing and masks for a good year or more now. And so there will be a broad but increasingly diminishing risk of social contact, and we must come to terms with that and fit in.
Indeed. Judge, I see that Nokulunga Makopo
Yes.
raised, the hand is raised there. Let's hear you, Nokulunga.
Thank you so much, Ronel. Good evening, DJP.
Hello.
Thank you so much for the talk, and it to extent does address some of the concerns that we've had and that we've briefly discussed in our chat. I have just one or two things that I could also raise, and I would link them up insofar as accessibility, whether we proceed to virtual or we proceed to the physical court. Insofar as the matters proceeding virtually, Judge, is there a uniformity on a way in which we could have insofar as access to the rolls? Because not all registrars do actually put up the rolls in the Johannesburg website. And sometimes you'll find people scrambling a few minutes before court, just trying to find out from who the judge's registrar or who else has access to the link to that court. And I think sometimes that can also be a problem insofar as the virtual court is concerned.
Yes. Well, I don't know the details of that. Clearly, every single court should have transmitted that to the professions. There's a whole list of people who receive them. What I do personally is I've got myself linked in on the Johannesburg Bar circulation, because I monitor the fact that these rolls have gone out. So I know that they're published as a matter of course there, and I'm not aware of any not having been published there. And of course, they're published elsewhere as well. The attorneys have websites where these are done too. I'm not sure what exact arrangements your own bar have, but if there are problems about accessing rolls, then the appropriate person to discuss the details of that with is the chief registrar, Roland Bramdor. She's in charge of making sure that happens. So if there's a specific question, effectively it's not systemic, but there's somebody who's dropped the ball, pick it up with her so that she can take the appropriate steps to make sure who's ever responsible for dropping the ball is properly conscientized, and see whether in fact it is a systemic problem or simply an oversight.
Okay.
What would be really very, very nice, I dream now, is that the Johannesburg High Court could have its own server and its own website where all the stuff would go up. Now,
because we're relying, and sorry, Judge, we're relying a lot on the Johannesburg Society of Advocates website, and some attorneys rely a lot on the Attorneys Association.
No. Yes, no, that's exactly right. Well, I've had a recent approach from the IT boffins at the Johannesburg Bar about engaging with internet service providers about effectively sponsoring some kind of website for us. It's very early days yet, but it would be wonderful, once again, my target date, if on the first day of term 2023, we could have a website where all our roles go up, all the judgments go up, etc., etc. Have a total full service site. That would be marvelous. Certainly, the state's not going to provide the funds for it, and so if it's not provided in the way that I've described, we're not going to have it. But it's too early to be assured that we can pull that off. So, but nevertheless, sort of watch this space.
All right. Thank you so much.
Thank you for your question. Also, Judge, we have, it appears, more a comment, but let me translate that to a question. To what extent is there the possibility that we as practitioners can expect a more uniform a set of directors between Johannesburg and Pretoria? That's a question from Advocate Mafotse.
Yes. Well, there's two answers to that. Under COVID, there has been one uniform set of directives. For reasons which are hard to understand, implementation has not been uniform, and I don't really understand how that could come about, but that is so. I suppose that's the problem, is that where you have a critical mass of work done in two different places, even when we are part of the same division, there's a kind of a subculture about how things are done that evolve, just the way life is. But over and above that, as you'll appreciate, what we've been doing up to now on a very short-term basis is going to have to find its way into the practice manual. The judge president some years ago made it quite clear that there shall be a uniform practice manual for the division, so that practitioners don't have to guess every time they cross the IXGA what is required. I drafted a uniform practice manual in late 2019, and COVID got in the way of moving forward on that. And as we speak, I'm in discussion with members of the Pretoria bench about moving that forward. It won't happen until the JP's back with us. He'll be serving in the Constitutional Court until the end of the second term. So he'll be back in the saddle from effectively July. And what I expect to happen by the end of the year is for the uniform code to be updated with what's been required in the last 2 years, to be agreed upon and to be issued, so that ideally, once again, it will take effect from the first day of the first term of 2023. And then the agony which I appreciate practitioners have been put into, of having to consult several directives to know which way they must jump, will come to an end, and everything will have one source. One of the things we've been very bad about in regard to the practice manual, particularly given the size to which it is now grown, is monitoring and updating it in a systematic fashion. That's one of the innovations which I recommended in doing the uniform draft. And in the Johannesburg committee system, most of the judges are involved in consultative committees on all various things. There is a practice manual committee which will be tasked with monitoring problems and things as they come up, things for clarification, things for amendment, additional things, innovations, reforms, with which we can consult the profession. And at regular intervals, let's say at the end of June and at the end of November every year, one will issue amendments, and then everybody will know exactly where they are. And so will the publishers, because then if you take, for example, Erasmus, where these things are published, they too can capture them, and one doesn't have to worry about whether the the photocopied thing that you've got stapled in your drawer is still up to date.
Yes.
You'll have to consult the thing, and it'll always be authoritative and right up to the date. Yes. So we're going that way, and hopefully we can put all of those things in place, and everything will be apple pie by then.
Yes. Judge, and I see I'm stealing a little bit of time, but purely because of the topic. I'm normally very good with cutoff. I can incorporate the last two questions as one. From Advocate Alexia Vosloo-David, she asks whether the full return will be formally communicated to practitioners in order to prevent any confusion on the return. on what platform will it happen? And then to wrap things up, we would also like to know if there is a single platform to which practitioners can direct either suggestions or give feedback on implementation. So how will we know? When will we know? And who do we communicate with on what platform about suggestions?
Yeah, right. Well, certainly there will be a formal announcement made. What we have already communicated is that our provisional decision is we're all back on the 17th of July full-time in Johannesburg. And the only thing that's going to inhibit that will be either a outbreak of COVID that seriously threatens the prudence of that, or we have an IT breakdown, or the air conditioning in the courts don't work. So what I have said to practitioners is plan your life on the assumption you're going to be back in physical court on the 17th of July. Save for these particular examples I've given earlier on, where likewise there will be a formal communication saying after hours urgence, etc., will remain video linked. The rest is going to be in court. There's also going to be a reorganization in Johannesburg of the courts which are used. I've thought for a long time the courts which we've allocated to different types of matters has been quite silly. The divorce courts on the 11th floor, where 100 odd people have to cram into those awful lifts and go up to the 11th floor. So the utilization of courts in order to keep the traffic out of the lifts will be implemented. The two big courts on the ground floor will certainly be the unopposed motion courts, and subject to other considerations which I have to weigh, the four other courts in the old building, the one on the west, on the east side, and the three on the west side, we'll probably use for trials. So the public will never get upstairs unless there's some other reason to do so. We'll have the appeals on the top floor. We'll have the opposed motions on another floor. And what we'll do is put the courts, we'll arrange the courts in such a way that the least number of people have to travel the furthest up to the 11th floor. So that's what will happen there. Then you asked, in the meantime, if one has comments and so forth, what platform do we use? Well, for the moment, an email to me or to my secretary is the only effective way of communicating that. If we're able to get a proper website, of course, it would be wonderful to have an open channel there, where at any time of day or night, one needs a catharsis. One can post a comment about what is thought to be required.
Mm-hmm.
Whether that's such a good idea remains to be seen. But for the moment, if you've got any idea, I'm very open to hearing what you have to say. It's much more useful, in fact. It's easy to digest. The odd comment or query or suggestion that comes in at 1 or 2 a week, rather than to get 50 comments all at once. You get a bit zombie-like if you've got to deal with it. And when you experience a problem, it might be relatively trivial, but if you can see a way to overcome something that's silly or burdensome or unnecessary or duplication, then send me an email so that I can incorporate it. I'm constantly making notes that are anticipating revisions to the practice manual and the directives. And that's a useful way from the way I like to work to get that information.
Indeed. Judge, We've taken more of your time than we intended to. From our side, and I'm sure I speak for all the delegates as well, but especially the SA Bar Association, thank you for taking the time. From what you've said, I doubt very much that this is going to be our last engagement. I see in the background behind you, Judge, that your beautiful dog joined the conversation.
No,
as well. I don't know if you saw.
He's my honorary registrar, yes.
But thank you so much for your time. It's brought us a little bit closer to what now seems to be a daunting reality, as much as remote working was a daunting reality.
Yes.
But it seems that in what you've shared, that you've identified probably some of the most crucial issues that would have caused a pushback. It is being addressed, and we appreciate that you've shared it with us on this platform. As we always say, the recording is available on the SA Bar Association's website of this engagement as well. And if there are any other questions from delegates, as you heard our Deputy Judge President extended what appears to be a fairly open line of communication as far as engagement by email is concerned to him or his registrar. Judge, thank you very, very much, and we look forward to seeing you again. And
Super.
We trust that what you envisage and what's behind it will come our way and come to fruition. Thank you very much, Judge.
A pleasure. Thank you very much, and good afternoon to all of you.
Good afternoon, Judge.
Bye-bye.